No, he can wait till let him. Let's finish the other ones who've been waiting. Okay, next item is number 37, 139 Lake Promenade. Application to construct a new detached dwelling with an attached garage. And we have on this cover letter, supporting materials, TRCA, 2 letters of opposition. And we have, I guess, this matter was deferred from June 24, 2021, so we have all the materials from that. Planning was asking for a deferral. Mr. Brown advised he wished to proceed. Planning and the additional materials has, first of all, we have the revision. Revision paid with highlighted revisions on a notice sheet and revised plans. And planning has advised that notwithstanding that, there's a deferral memo still stands, but that's all we have. On urban forestry's requesting conditions 2 and 3. Mr. Brown?
Good afternoon, good evening, Mr. Chairman and members of the committee. I'm happy to have the opportunity to chat. Unfortunately, I don't get to be there in person with my usual Bristol board, but I'm going to try and make use of the virtual presentations, which I'm learning over the last year. Mr. Chairman and members of the committee, this is an application that's been going on for more than a year in terms of the consultation and commitment my client has made to respond to many of the issues raised to date. And I opened up by saying we wanted to proceed because I think we've hit the mark on many of the fronts. And for instance, the list of variances before you, we have eliminated the variance for the decks, the rear deck, and we've reduced the variance for the second floor deck. So those are variances 4 and 5 to 9.6 from 24.5. I just point those out for a minute to tell you that we did that because Daniel from planning had asked for that. That came after the initial consultation with Sabrina, who's now the manager in Toronto. So even when we had thought we were finished in the process with the first planner on the file, good for Sabrina, she got promoted and I'm happy for her. But my client then had to make some other changes, which is okay. That's part of the consultation process. Those rear deck removals weren't at the request of the adjacent neighbors. You'll notice that there's no objections from them. My clients worked cooperatively with them, and you'll see if you can go to my presentation materials, which I don't know if these are them. I sent them in through Ali, our architect, which has first the A Lake Promenade frontage. It's got an A on it, and there's presentation materials.
That's the first supporting material, Nicole.
Oh, so, yeah.
The second one is the Long Branch character islands. The first one is your drawings.
There we go. So if you go to A for a minute, what A shows you is, in addition to those changes, they eliminated the previous variance for building depth and building length. You can see the house is actually, whether you go to Google Maps or this plan, which I had them outline the built form next door because, to be honest, I couldn't see it when it was on a survey, and I saw it better when I went to the site. You can see that it's modest in terms of its depth compared to the neighboring properties. They were happy that we didn't block any of their views to the lake. We also have an agreement that when we do the erosion wall that gets done, they're going to have access because they need to fix theirs. It's been a very cooperative process with the adjacent neighbors. In terms of the remaining variance for density, you heard from other applicants about the density in this area. It's actually 0.54 when you take out the exclusion for the hazard lands. The size of the house is not out of keeping with others that have been approved in the area. We looked at the density that was approved by T-Lab down the street at 1.44. So again, all of those issues have been addressed, and Sabrina had asked us also if we would reduce the, in addition to getting rid of the length, the height. So if you take a look just a little further down on B, the reason I showed you B, just in case you don't get to walk around the area, the guidelines, which I'll address in a minute, help us understand what's important to the association. And I know my friend before me, Mr. Flynn, said, look, they're guidelines, but they are helpful. They let us understand what the community who lives there every day, not me who does a hearing and leaves, what they think is important. And I know Ms. Mercado, I think, was one of probably the authors and helped on the input of all those guidelines. I know she's actively involved and they mean something. So we looked at them and I said, give me an interplay of all the houses in the area because there's different variations in design. Some do have below grade, some have at grade in terms of their driveways. Some have peaked roof, flat roofs, some are 2, some are 3 stories. Our variance to height was reduced now. They asked us to take a foot off. I work better in feet. We took 18 inches off. So we're now 9.97 instead of 9.5. We brought it down from what it was before in terms of the building height. We were at 10.5. So we did that in response to planning's request for height. And the same on the side wall of the height. It used to be 10.5. It's now 7.79. So it brought the massing down. So it's not so different than the variations you see from the heights of the homes in the area. So when you look, and then the final variance was for the shoreline, you have a letter on file from the TRCA, which confirms that they have no objections any longer. We made the revisions in accordance with their comments and they're on side. That took a lot of work over the last year. The final comment I'm going to make is the reason that the planning department put for an adjournment, and I get it. Look, there's different planners, and during COVID, we got to change of planners, but there's no reason for it. And the reason I say that is I took seriously the design guidelines. And in August, there was a response put in about the design guidelines that pretty well confirms, but for the building height variance, where we show that the upper floor is entirely integrated into the roof, and we complied with what planning staff told us to do for those design guidelines. All of the other guidelines of building face, building depth, a finished ground floor, roof lines, front entrance facade, windows, facade elements, materiality, driveways and garage. I'm going through them all not to bore you. They're not boring, they're important. We don't have any variances relating to any of them. So we did that, and that was submitted back in August. It's okay that Daniel might not have had time to look at them, but they've been on file since August, and we made all the other changes that we were asked to do. The only other comment that came up, if you can go back up to the site plan A, was about trees. The trees number 1, 2, and 3 that they speak of, and this is where I wish I was there to point it out, but if you look on the left side closest to the street, one of them is, there you go, thank you, right there. That's one of them, which we are actually going to have more grass area adjacent to it. We're taking away paving. So we will not affect it in any way, shape, or form other than positively during construction. We're subject to tree bylaws anyways, but we can't touch it and we won't. Tree number 2 they're speaking of is even further away to the northeast, if I could, of the northeast corner of the property. If you can put that arrow there. Thank you.
Yeah, Mr. Brown, if you can wrap up, please. Thanks.
Okay, we're not touching that one. And the third tree in the backyard is about 76 feet away. So we will not be touching any of the trees that were raised in the objection letters. Our neighbors adjacent to have not objected. Thank you. And any questions you'll have, I'll happy to answer or respond to.
Okay, thank you. Any questions for Mr. Brown at this point? Okay, so we only have 2 speakers, both from the Long Branch Association. Unless it's just going to be Christine again. You can let us know. But it looks we don't have any communication from neighbors on this.
Hello, Mr. Chair. It's Christine Mercado. I'm the chair of the Long Branch Neighborhood Association. We do acknowledge that the applicant has made a number of changes on this application. And we do agree that he has hit the mark on many fronts. But as he said just in his presentation, he hit it on many fronts, but not all. So if you could pull up my letter onto page 3. It should be pointed out that planning hasn't written a complete report to speak to the compliancy with the guidelines, which is clarification of OP 4.1.5. And this has been communicated to the applicant. So I actually did respond and acknowledge the changes. And I did speak on where it actually missed the mark as far as the guidelines applied. So on page number 7, we still do have objections based on 4.1.5, which is height, massing, and density measured by FSI, and policy E prevailing location and design of garages. So on page 8, are you actually seeing my letter, Mr. Chair?
Well,
I don't see it coming up.
I'm seeing my copy. Perhaps
okay,
Nicole,
that's
we
fine.
can get
then.
it up on the screen. It's the second supporting. No, it's the opposition letter. The second one, opposition 2.
Okay. Thank you. So if you go to page 8 of the letter, there still is a significant FSI variance. So there are 30-foot lots that are in the area, and generally a 0.54, if you take away the top of bank, 0.54 FSI for a 30-foot wide lot is actually higher than that is higher than the ceiling of what's being approved in the area. So there are examples on Crystal, which is right around the corner, as well as 28th Street, which is also around the corner. It's still a significant FSI variance. So it's a large home that fills up the building envelope and presents as 2 stories above a garage. And that is the burn for us. It's a condition that does not exist in the immediate neighborhood and is not in substantial numbers in the broader neighborhood. Our photo array is the block between Crystal and 28th, and 2 stories above a dominant garage does not exist. And it doesn't on the north side either, where the houses are actually substantially smaller. Therefore, it's not prevailing in the immediate context. This was also recently refused at 106 Lake Promenade. 2 stories above a garage didn't exist on that block, that next block over either. The applicant's photo array is wide-reaching to the broader neighborhood, pointing out a few scattered examples of perceived 3rd stories in a variety of homes in a variety of building types that are not single-family dwellings. In looking at these properties, none were subject to the guidelines, and none are in the immediate context as prescribed in OPA 320 as abutting the same street in the immediate adjacent blocks. In the guidelines, it's further clarified as the 3 concentric circles of evaluation. So it's adjacent properties, the street, and the block segment. So on page 10 of our letter, the guidelines offer further clarification by stating that 1 to 2 story dwellings should be reinforced. On page 23, it offers further clarification by suggesting windows be at existing reference size, which is not the main floor, to be above the garage. And on page 24, it describes why, as it breaks the connection to the street. On page 29, the guidelines explain that dominant garages take away from the character of the neighborhood if it dominates the front facade. And like I mentioned before, 2 stories above a garage does not exist. So therefore, it does not respect and reinforce the character of the neighborhood in the immediate context as prescribed by the official plan. The FSI variance is proposing is an FSI that is beyond the ceiling of what is being approved for similar frontage lots. And this is a large house. It's over 4,000 square feet. As such, it is subject to comment from the planning department and subject to the guidelines. So the applicant's own exhibit demonstrates on how this application does not fit into the character in the immediate context, and as they couldn't find an example of it. And we would have supported deferral, but now that application is in front of us, we would request refusal as it fails the 4 test, as it does not comply with the policies of the OP and the intent and purpose of the bylaws. Thank you.
Thank you, Ms. Mercado. Wow, you did it. This time you were 10 seconds off 5 minutes. You must be practicing. Okay, is Andy Scholl speaking as well on this one or not?
Mr. Scholes, no, I think the applicant has actually spoken well to the trees.
Okay.
Our biggest problem was built form.
Okay, thank you. Okay, Mr. Brown, so please can we have your rebuttal to Ms. Mercado's presentation?
I think it's really important.
Does anyone have any questions first for Ms. Mercado at this point? Okay, go ahead.
I think it's very important, Mr. Chairman, not to mix up OP policy and bylaw standards with a guideline. And while guidelines are important to consider, and we did that for the built form envelope, there is no bylaw standard in this area, unlike others, that says 2 stories, not 3. There's no bylaw standard other than front elevations of the access to the house that says how many stories above a garage or not. And it's also somewhat erroneous, in my respectful submission, to try and say that the guideline now elevates a bylaw standard we're not varying 3 stories or 2 stories to be some sort of guide to what ought to be built on the property. There is no variance to the number of stories. There is no variance to how many stories above a garage or not. And it's interesting, if truly the concern is about heights and impacts, because there aren't any. we don't have any physical built form impacts as a result of the height. The most affected neighbors are not objecting. If the association is to now say, oh, that's what we're concerned about, I listened to the previous application, and in my 32 years, we worked on a lot of below-grade garages. Mr. Flynn was correct. Some people would say, bring the house down so you get your windows closer to grade and have a below-grade garage. And there used to be issues about drainage, which I know can be addressed these days. But again, my client chose to go with the at-grade garage, not a below-grade, despite there being those on the street. But to raise these guidelines for one issue and say, we want to tell you how you should design your windows and your location of X, Y, and Z, when I'm not seeking variances, and I've got a client in terms of built form and density that has a built form that's shorter than the two homes next door. So a number, the numerical value, isn't the determining factor. And in this instance, this is modest in terms of its built form, its envelope, its depth, side yard setbacks, to forget about down the street, what's right next door to us. And the character of the neighborhood isn't defined by the guidelines. It's the neighborhood official plan policies. It's the yellow overlay in the official plan. And all of those homes we showed you are in the neighborhood designation. They're not apartment buildings. We included some apartment buildings to show you how apartment buildings and single family homes are working eclectically in an area together. But I'm somewhat shocked by the attempt to elevate a guideline as if it invents a new official plan policy or zoning bylaw standard. I've worked on many of these variance applications over the last 32 years, and I've never seen that successfully argued or actually put forward when an applicant moves forward to appropriately design the house to fit within the fabric of those immediately abutting houses. Forget about down the street. Those are my submissions.
Okay, thank you, Mr. Brown. Any questions for Mr. Brown or Ms. Mercado? Or is we ready to take this into committee for a decision? So at the end of the day, I don't have the final, the revised one. How many variances do we have here? Is it reduced to 3, I think?
You have 1, 2, 3,
Should be
5.
5. Variance 4 was deleted for the
Right.
number of rear platforms.
Okay, so that's the current application. So I think noteworthy, we have 5 variances. The other one had 13. So I think.
And
the
remember,
comment-
variance 5
so yeah, like I
was
don't know if
reduced.
you're supposed to get, meet every single one of the guidelines. I think, in terms of moving closer or how many, so this is the one sticking point that they seem to have. They've acknowledged that you've dealt with a number of the other ones. So that's, I guess, the situation. The guidelines are to be followed to the T. I think you made some valid points there. So let's see, committee members have any more questions for either Mr. Brown, or for Ms. Mercado, or are we ready to, someone ready to weigh in with a motion?
Danny Belisma just had some questions about heights within elevations or there's no cross section here, so I just wanted to reference it says side elevation east, A09. That's the only one I can look at, I believe, that shows me the heights for the ceiling. Is that correct?
Our side is 7.79 instead of 7.
Sorry, no, I'm just trying to clarify the heights inside the building. I just want you to tell me if I'm right or wrong. There's a elevation. I think I just mentioned that it was A09. Page A09, as you call the page.
Okay.
So the basement is, it says 10 feet, but it's a 9-foot floor to ceiling height in the basement,
Correct.
8 foot in the first floor,
Correct.
10 feet in the second floor, and 9 feet in the third floor.
Correct.
Those are all your heights, correct?
Yeah.
Okay, because it's not, I don't see floor to ceiling. I just concluded that the floor assembly is a foot. Okay, so that accounts for part of the height issue, right?
Correct. And it's really the front of the house that faces the street actually complies with the 7. It's the back of the house as it drops off a bit that creates the variance for the side wall.
Right, okay. No, I just wanted to clarify the height of the floor to ceiling heights, and because I didn't see them until I did my own conclusions. Thank you.
Let me just confirm I have Ali on the line. 1 minute. Ali, the floor to ceiling heights that he said, those were correct. Is that right? Yeah, it's less than 9 feet floor to ceilings on each floor for my architect.
Okay, which is, I think we had another one today where it was 10, 10, and 10.
Yeah,
I
this
think
is
Mr.
smaller in terms of what I've
Mr.
typically done.
Taylor does that. Okay, any other questions for Mr. Brown or Ms. Mercado, or is someone ready to weigh in?
Just a quick question for Mr. Brown with regards to the remaining platform that's being sought. What are, since there's no interior details on your plans, I just wanted to know what room that's coming out of. Is it coming off of a kitchen, out of a bedroom, or?
Out of the second floor platform?
Yeah.
That's off the master bedroom.
Thank you.
Thank you.
Okay. Mr. Komarek, you said you had a couple of questions or just the one?
Just that one.
Okay.
Thank you.
Any other questions, or we'll bring it into committee for a decision?
I
Mr.
think I'm going
Taylor.
to attempt at a motion. Oh, sorry. Go ahead.
Sorry, Mr. Taylor, you had your hand up?
Don, did you want to go?
No. Go ahead, Stan.
Oh, Stan? Go ahead, Stan.
Okay, sorry. Yeah, given the attempt that's been made here to fit with all of the reductions that have been made, I think the applicants made a valid attempt to try to make something here that works. I believe it can meet the 4 tests. It does meet the 4 tests, and therefore I'd like to move approval, subject to forestry conditions 2 and 3, and transportation conditions 1 through 5, and I guess as revised.
Thank you, Mr. Komarek. Seconder for that motion? Mr. Taylor, thank you. All in favor?
Can I just offer some real quick commentary?
Yep.
Mr. Brown captured the essence of my thinking on our consideration of this proposal. I couldn't have said it better myself. And as I said before, and I'll just say it very briefly again, when we consider impact of a proposal, we have to compare what's proposed with the current zoning standards. In this case, there are no side yard requirements, rear yard requirements, front yard requirements, a modest adjustment to height. So this fits, and I second the motion.
Yeah, and no neighbors here in opposition as well, just the LNBA.
Yeah.
LBNA.
Sorry, Stan, I don't see transportation comments.
You know what? I may have mixed up the two in my note taking here. If they're not
Okay,
there,
so-
then that's probably
So
to do with,
just forestry, right?
yes, the 2 forestry conditions. Thank you.
Okay.
Okay, all in favor? Unanimous. Thank you, Mr. Brown, and thank you, Christine.
Thank you, Mr. Chairman. Thank you, members. Be well.
Okay. Our next application is item number 38, 24 Totteridge Road. It's an application for a detached dwelling with an attached garage. There are 5 variants and 13 letters of support. And we have urban forestry condition number 1. This matter was deferred from August 12, 2021 hearing. The speaker is Marin Zabzuni.
Good
Good
evening,
evening.
Mr. Chair and committee members. My name is Marin Zabzuni at 1140 the Queensway.
Okay. Don't think we need a fulsome presentation. Is there anything you'd like to advise the committee members of? See if they have any questions. Pretty straightforward. You're okay with the urban forestry condition? And you
Yeah.
have 13 letters of support, and we also have the materials from the previous hearing, which does anyone have any questions for Mr. Zabzuni? And if not, is someone ready for a motion? Oh, I'm sorry, I'm looking at my papers. You're all very truncated, so I didn't see your hand up. Thank you, Mr. Taylor. Like to weigh in with a motion?
Yes, thank you, Mr. Chair. Yeah, I'm satisfied the 4 requested variances, or 5, meet the 4 tests under the Planning Act, and I move approval subject to urban forestry condition 1.
Thank you. Seconder for that? Mr. Komarek, all in favor? Unanimous. Thank you, Mr. Zabzuni.
Thank you.
Okay, our last application, we go back to item number 34. 16 Daisy Avenue. It's an application to legalize and maintain a rear deck under construction. There are 2 variances, the area of the platform and the setback from the common lot line. And on this application, we have 2 variances, photos. We have, yeah, now this matter was deferred. I was going to ask a question as well. From November the 7th, 2019. It's before COVID. And that's my question is, why is this taking so long to get before us, Mr. Schwady, given it's something under construction? I don't know if they stopped construction or they finished it, but I'd like to hear that from you as well. And we have the 2 letters of opposition.
I mean, can you hear me?
And yeah, we have as speakers on this, I guess.
Okay.
Mr.
Great.
Flynn is here acting on behalf of the neighbor, and we have Ernest Dumphy. We don't have an address for the gentleman, and as well Andy Schultz from the Long Branch Association. So, Mr. Schwady,
Okay.
the floor is yours.
Okay, yeah, the house was, I mean, the deck was built without permit, and inspector was there. to
Sorry,
check for
I'm having
the-
trouble hearing you, sir. Can you try speaking?
Hello, can you hear me?
Yes, but please continue.
Yeah, if you see the pictures, this deck was built without a regular permit. It was a balcony approved before in previous committee of adjustment. Then the owner built a deck over there, and it was a refusal from the planner to revise the drawings, but for some reason we are not ready to defer the project, I mean the hearing, and now we did the revisions and ready to answer all the questions. The revision is done regarding the setbacks and the area of the deck, the rear. If you see the pictures, this is existing deck, which is going to be shorter than as it is right now, if you see the pictures. We got letter of support from the neighbors at the rear of the house in Elder. In Elder, yes, and I know very well that there are two letters that are opposing this proposition for the deck and regarding privacy fence. Actually, I don't have any comment from the planning staff, and we tried the owner. I have the date that we tried to reach the owners at number 10, because they're the most concerned, but it was impossible. So we sent email to Mr. Flynn in June, September. The owner called him in May 2020. They did talk together, as I know, but no answer. So we wanted to have an agreement what to do with the deck, but at the end of the day, we decided ourselves with the owner to revise the drawings we applied in this front of you.
So why has this application it was deferred, and I just checked it back to find the minutes. It was deferred in order to revise the application to be more in keeping and to consult with concerned neighbors. And the neighbors, number 10
Yes.
agreed, Mr. Flynn representing number 10 agreed. It's been 2 years, and it's already been built. So they enjoyed 2 years of that without coming back here. I want to know why this is dragged on and
I-
just sat like this for almost 2 years.
I'm not able to say that for the owner. Maybe he was sick or he had any problem, but I am back here.
Yeah, I see
Okay.
Mr. Rubinoff was the agent that back 2 years ago, so I don't know, you were maybe just recently retained on this?
No, the thing is here that I am the designer for this house from the beginning.
Oh, I see, okay.
You know, I am the designer. They hired Mr. Rubinoff. I was not able at that time. Then it was deferred. Mr. Rubinoff knows this better, but now I'm like a brand new guy that did the application for revision.
And are we dealing with the same exact oh no, it's been slightly, it was 18, now it's 16, because I'm saying, is it exactly the same as what was before us 2 years ago? That got deferred to make
No,
changes? I
not
see it
the
has
same.
gone down, it's now 16.64 meters. And I believe it
And,
was more before,
The
18.
the setback and the setback from 1.8 meter, I mean from 0.35 before, there is a setback 0.81.
Okay,
But I just want to mention too that you decide the neighbor number 18 is the same owner as is the number 16.
okay, so is it the neighbor
So-
at 18 that's objecting? The other
No,
side, was
he's
there
the
a lot
owner.
severance here? Was that originally one lot, or was there a?
Yes, no, it was not a lot severance. The owner is the same. The owner of number 16 is the owner of number 18 too.
Okay. So who is objecting here? Number 10,
I don't know.
Mr. Flynn.
Number
is here.
10,
Yes, they were around
number
last-
10. Okay.
Okay, so
I
I think
I
you had to
can
wrap
imagine.
up also. I've let you go, you over 5 minutes, sir. If you'd just like to summarize.
Okay.
Anything else to add?
Okay.
Okay, does anyone have any
You want me to
questions?
talk?
Anyone have any questions for Mr. Spati before we move on to hear from Mr. Flynn?
Yeah, Danny Bellissimo does. I'm having a really hard time understanding what this gentleman is saying. Maybe it's my audio here, but could I just clarify and he can tell me whether I'm right or wrong? The existing house condition had a balcony similar to the one beside. Is that correct? At one point, and then it was turned into a large deck with stairs coming down.
Can I answer? Yeah.
Yeah.
Okay.
And that was
if you see the survey, because
No, sorry.
there was a balcony there before.
Yeah, that's what there's a balcony before, like this, like the existing neighbor balcony in your photograph. And then it was extended with stairs, and that was built
Exactly.
with a building permit. That was built without a building permit.
Exactly, it was extended without a building permit. Yes.
Without a building permit. Okay, so what we see presently in the photograph has not been approved by the buildings department. Okay, thank you. I couldn't hear what you were saying. So
Yeah.
it's an illegal condition, basically. Thank you.
Thank you. Okay, let's hear then from Mr. Flynn on behalf of the neighbor at number 10, I believe. Is that correct?
This application has been more than frustrating to try and deal with. When it was first heard 2 years ago, we had a good meeting with the representative, the agent, at the hearing and discussed changes which we believed at the time would be instituted. Immediately that agent was fired and nothing occurred. I spent some time trying to chase down a new agent or a representative of some sort and an architect, and obviously got nowhere. We have, over the last year, been chasing building department to act on their order to comply,
Exactly.
and they haven't exactly cooperated. It's not that they didn't agree with us, it's just that they don't like to proceed to charges, and I can understand why. But the bottom line is the counselor's office and ourselves made every effort we could until the building department finally told the applicant that they were going to charge him if he didn't get back to committee and do something. That's when things started to happen again. Mary Campbell from Councillor Grimes' office was very involved. There was numerous communications on the subject back and forth. And finally, here we are at a hearing date. But I would say the applicant has acted disingenuously right from the beginning. And I don't know about the rumors I heard, so I won't even bother to repeat them. But he doesn't believe that he's going to lose. He never did believe that he was going to be forced to make a change. And I don't know what to tell you about that, but
Yeah.
I think, in my humble view, and the committee is probably aware that I rarely take a contract to oppose anything.
That's true.
This is probably twice in the last 5 years, or the second one in the last 5 years. And I would not agree to represent an opposition unless I truly believed that they were in the right and that the applicant was in the wrong. I often refuse applications or to represent applications because I don't believe in them. And I think that any good planner will do that. And I think what we have here is a situation exactly like that, where the applicant really didn't give a damn about anybody or anything except what he wanted. And it was poor planning on his part, and he just didn't care about the neighbors and the impact that he was going to have upon them. And if you've seen it, you will know that it is a ghastly construction.
Yes.
And he would have never been given a permit to build it 2 years ago or 3 years ago, whenever it was. But it was built 3 years ago. It's not something under construction.
Exactly.
It has been constructed, and it continues to be used. And I believe that it should be refused.
Okay, thank you, Mr. Flynn. I was going to admonish you and say, if you're the agent acting for a neighbor, why did you sit back and let this go on as an as-built situation for 2 years? And that's why a couple of weeks ago, someone asked for a deferral, and I said, I want to make sure this is on the very next, when you don't have not built something, it's at your peril if you have a deferral or whatever, because here they already have it built. And it's gone on for 2 years, and now you tell me you were pushing, and it was the building department that was dragging their feet on this. And it shouldn't show as under construction because it appears in the photo it's been built, and it was probably built when it was back here 2 years ago.
It was.
So they've enjoyed 2 years of, no wonder he thinks he can get away, because he's enjoyed it for 2 years after the deferral and nothing happened. So any other questions for Mr. Flynn? Okay, I guess is we have Ernest Dunphy, we don't have an address?
Through you, Mr. Chair, Ernest Dunphy is actually from 10 Daisy, which Michael Flynn is representing.
Oh, okay. Okay, so we've heard from our last speaker. So Mr. Spady, and if you could please, in addition to Mr. Bellissimo, who's sitting in his home office, I couldn't hear you. It was very difficult to hear you. So if you can try to speak, enunciate a little clearer, it's to your benefit.
I know. Sorry, Mr. Chair, there's still Andy Choles from...
Andy Choles, because he hasn't been around for the last two hearings. I figured he wasn't, he was on vacation or something. Okay, so let's hear from Andy Choles then. Sorry,
Andy. I'm here, sir.
Okay.
My name is Andy Choles, live at 12 Jasmine Avenue in Long Branch. I'm feeling I'm a little late to this party. I'm here to oppose the addition of this rather large deck on the rear of 16 Daisy. Though I don't live near the home, I'm very familiar with adverse overlook of decks built on the back of homes in the area. Applications to legalize the deck, so I see it has been built without a permit. Second story walkout to an excessive either 19 or 16.69 meter square deck will surely result in unwelcome overlook to the neighborhood properties. Despite the fact the applicant has polled his neighbors at the end of his yard and received a number of agreeable comments, the deck will remain in the neighborhood after these owners move out. Missing on the list of approvals are the neighbors immediately to the east of this property, and most importantly, 18 Daisy, which I understand is the owner of the other half, the semi-detached. Perhaps some neighbor had second thoughts about agreeing to this deck and seeing it under construction. Sometimes overhead drawings of a permit don't quite give enough perspective on the impact on your lot. I think the bylaws of the city provide consistent regulation that might control overbuilds and put a stop to something that might prove to be disruptive to the neighborhood. Looking at the drawings, it's already a small deck which matches the other half of the semi-detached house. Perhaps this applicant can keep the stairs or construct some sort of stairs down to the yard and construct a patio area that isn't going to have such overlook. This, I would only hope that if he does that, they still leave generous allowances for soft landscaping, plants, and possibly the planting of a tree. I would agree with comments of the city planning staff in the report and urge the committee to reject this application.
Yeah, thank you. I don't think we can plan on what he's going to build to comply or how he's going to change it. It's what's before us, and and I guess if it gets, I guess what's legal is just the smaller deck. So if in event of a refusal after the appeal period, since it's already built, it would have to be demolished. So, okay, Mr. Spatty, if you can respond to the concerns of rebut what Mr. Flynn and Mr. Trolls had to say. You have 5 minutes maximum.
I don't know. In his letter, opposing letter, he's saying that number 16 belongs to Long Branch, and his house is more than 1 kilometer far away from.
He's here. He's here as he's here as a Long Branch representative. He's not here on his own record.
It's not in Long Branch, but it's in Etobicoke Lakeshore. Anyway, you have the right to talk, but you are far away, coming in Lakeshore, Etobicoke, and when you are mentioning that this property belongs in Long Branch, so I think you know nothing about this property. Just maybe one visitor, or maybe you know the neighbor at number 10. Anyway, I'm not worried for that because it was clear for me regarding Mr. Flynn. I mean, committee members, maybe you may take his side. I understand it's too late. These people enjoyed in this situation the deck. I understand this, but it's not true that when Mr. Flynn is saying that an order it was issued to remove the deck. You can see his letter. No, the inspector was there, and he asked to apply for a committee of adjustment, and I did it right away. The second, for revision, the owner has called Mr. Flynn too many times, and he never answered. It was built a fence, privacy fence, and the owner wanted to know if the owner of 10 was okay. They didn't show up. Even Mr. Flynn never answered. So I understand it's a deck built 2 years ago, but Mr. Flynn, you got to be more sincere with this thing. I really don't understand. You have talked with me only one time. And the other thing is, how do you know that Mr. Rubinov was fired? You are assuming. So
okay, first of all, direct your comments to me, to the chair. You don't talk directly to Mr. Flynn. Mr. Spatty, Mr. Spatty, make your direct your comments to the chair, not to Mr. Flynn. And let's hear about Mr. Scholes. Okay, maybe it's not Long Branch. Then if we reject what he has to say, if he's lives far away, and if this area, I was unaware that this is not part of Long Branch, so I apologize for that. But you have to respond to Mr. Flynn's comments without attacking Mr. Flynn, and also you're very difficult to understand.
I'm not attacking Mr. Flynn. Actually, he was attacking me.
Okay, so
he was attacking
let's
me.
deal with the substantive. This
committee. Okay.
Why should this building be built? Why should it be allowed to remain? Please respond to what he had to say.
One building is not the first time something is built without permit, but we are going through procedures. Yes. I was zoning, I got the zoning, I come to you, and then in front of the committee of adjustment for something that is built, but it happened. It's not that something new in Etobicoke that you got to be surprised, Mr. Chair or committee member. It's built wrong. I understand that, and we tried to do some revision. We couldn't reach Mr. Flynn. to revise the drawings, to talk with him, to do an arrangement. Then now we're coming here and he's saying that we talk a lot, we asked, we called and you didn't answer. So, but at the end of the day, you guys should decide for this thing.
Yeah, anyway, it's to me, it's egregious that this thing has been built and in that situation, and this matter was deferred 2 years ago. Sorry, 2 years
Chair,
less 2
then
months.
Yeah, I'm happy that the owners of the house are keeping alive in this situation and enjoying some sun. But I'm telling you, the privacy fence was built time ago.
Sorry, we're not talking about a privacy fence here. We're talking about the deck and the illegal stairs and the storage area under the stairs.
Oh, okay.
And that's what we're talking
area,
about here.
There is no storage area below the deck.
Yeah.
And the deck is revised. It's not like before. And I don't have any comment from the city, from the planner, except the first one where the deck was bigger. This time I didn't have any comment. So.
Yeah.
Mr. Chair, just to clarify, this is part of Long Branch.
This is part of Long Branch. There we go. So Mr. Chol spoke as he's an executive on the Long Branch Association.
I mean, then I don't know who put this notice of decision, Etobicoke Lakeshore. So,
okay, well,
tell me, it may be a committee of adjustment then, people that are working over there.
That is based on the ward, not the neighborhood, sir.
Yes, you put Etobicoke Lakeshore.
And Mr.
Right,
Spatty.
that is the ward name for the whole ward.
Okay.
Sir, are you a planner? Are you a registered planner?
No, I'm not.
Okay. All I want to know, you appear here. Don't ruin your reputation with this committee over one client. That's my advice to you.
But thank you. Thank you.
Okay.
But,
and you mentioned you were happy your client got to enjoy the sun. No one was taking away the right to the sun. They could have the sun on the deck, the rear balcony, but it's the stairs and the storage and everything else. So when you said, oh, I'm happy they got to enjoy the sun for 2 years, no one was trying to take away their sun. No one was trying to take away their sun. It's the illegal build that has gone on for 2 years. Okay, that's my beef. Committee members, any other questions, or let's take it in for a decision? Okay.
Could I ask a question of staff, please? I see here that this application has been before the committee, November 7th, 2019, and it says to legalize and maintain a rear deck under construction. And then the motion was by Neil Palmer that it be deferred to the next hearing in order to provide application opportunity to revise the application more in keeping with the zoning bylaw and consult with concerned neighbors. So my question to the staff is am I reading it correctly that the deck was under construction and it could have been stopped in 2019? Is that correct? Am I reading that 2019 application correctly?
Well, staff isn't going to know. I think it's the same situation. It was completely built. It was completely built. Mr. Spatty, he's asking staff. He's not asking you. Please, can you mute Mr. Spatty, please? The question was for Barb Botozic.
That's my understanding.
She's not going to know.
It's my understanding that it was under construction. I'm not sure if it was fully finished. It looks like they've made changes or they're proposing changes.
My interpretation of that, and I was not part of the motion, is that it could have been stopped at a certain point, but we don't know what point that was. So I have great difficulties with the fact that they just kept going while there was a motion to stop it. Thank you.
Yeah, Danny, I'm trying to look through the previous materials from November 19th to see if there was a photo, and I don't see one. But you're right. It shouldn't. Yeah, like, it still says partially constructed, but I believe it was constructed then, and it's constructed certainly for the last 2 years. So let's take it into committee then, if there's no further questions, for a decision. Mr. Pat Taylor, sorry. Didn't see your hand up.
Sorry. Yeah, I think there's a lot of interesting factors here and confusion about what happened and why and everything else. But I think if we can just focus on the merits of the application and consider whether or not it's reasonable to build a deck 0.81 meters from an attached neighbor when the bylaw requires 1.8 meters? I think the answer to that in my mind is obvious. No, it is not reasonable. Then we look at the area of this deck, 16.64 meters squared, where the bylaw allows 4 meters squared. Is that reasonable? No. This application fails in my mind on all 4 of the tests under the Planning Act, and I move refusal.
Thank you, Mr. Taylor. Do I have a seconder for that motion? Sophia Reddick, all in favor? The application is unanimously refused. Thank you, Mr. Ashbati, and thank you, Mr. Choles. And we now stand adjourned. And thank you, everyone, for a good meeting. And we'll see you next time.
Thank you, members. Have a good night.
Thank you, Barb.
Night all.